All right, welcome back. And on this week's edition of Wheel of Justice, I'd love to introduce my guest for today. She is Magistrate Court 8, Umuahia North, that's the headquarters right here in the city. Her name is His Worship Uzo Onuaha. Welcome to the studio.
Thank you very much, Ifeanyi.
All right. And we are going to be looking into bail and recognizance generally under sections 155 to 168 of the Acjl 2017. But before I continue, I'd love to recognize the presence of Agnes, who is representing Prawa. And as I always say, that I'm here to observe how things go. It's always nice to have you around. All right. Now, let's jump into our conversation for today. Now, a lot of persons hear about bail, and what Nigerians are quite familiar when it comes to bail is the issue of bail being free. But we're not towing that line today. We're looking at something different, and that is the bail and recognizance generally under sections 155 to 168 of the Acjl 2017. But let's start off from understanding what this is all about. The bail, recognizance, what are we looking at?
Okay. Thank you, Ifeanyi, for having me on the program today. Bail and recognizance, generally speaking, go hand in hand.
Okay.
I had to do a little bit of research so that we can communicate this to the grassroots, to the layman, to the man on the streets, so that everybody understands what exactly it is that we're talking about. So according to our Black's Law Dictionary, the 6th edition, bail means to procure release of one charged with an offense by ensuring his future attendance in courts and compelling him to remain within the jurisdiction of the courts. Right? Now, it also means to deliver a defendant to persons who, in the manner prescribed by law, become security for his appearance in courts.
Okay.
So what this means, what it tells us basically, is that the object of bail is to secure the attendance of a defendant. The defendant, of course, is the person that has been charged with an offense.
Okay.
Yes.
Now, understanding this part, you know that it's majorly just to make sure that, hey, you are not in jail, but each time the court needs you to appear, you have to appear.
Yes.
That's what it is. And somebody might hear recognizance, and just like I told you earlier, you'd think that it talks about persons who are popular, persons who are known in the community, and based on that aspect, because they are known, it's easier to get this bill. But you say it's different from that.
Yes. Recognizance, like I said, I mean, it goes hand in hand with bail. Now, definition also of recognizance is it's an obligation undertaken by a person.
Okay.
Generally a defendant still, of course, in a lawsuit, usually in a criminal case, to appear in court on a particular day. I mean, it's usually personal recognizance. More times than not, you don't need a surety for that.
Okay.
So that's where self-recognizance comes in. It's not, I would not say it's and it doesn't occur every day. It's not an everyday thing, but there are instances where a person will be granted bail on self-recognizance.
All right, because of time, let's jump into the sections of this particular law, and let's start from 155. We're going to look at it. Permit me to read from 155. Says, when a person is suspected to have committed an offense or is accused of an offense, is arrested or detained or appears or is brought before a court, he shall, subject to the provisions of this part, be entitled to bail. Now, it means that there are certain ways to get this bail, and this is where you come in. So let's going through 156 of 1 and 2. Let's get to understand what are in place when it comes to this.
Okay, it's pretty simple. A person that a court can order a person to be brought to before it, and I mean, first of all, like we already know, you're charged to court. Now, from the police station where the charge has been laid, the police can grant administrative bail to a person. That's what you're talking about.
Yes.
When someone comes from home to court. Now, while you're on administrative bail, you come to court. You have a right. You're entitled to bail from the court.
Okay.
Okay, you're entitled to that bail, and counsel to the defendant applies for bail for the defendant. Does that answer?
That answers it. That answers it. Now, for clarity, let me just go through 2 of 156 states. The court may, on production of the person or subsequently, make such order to give such directives as it considers appropriate in the circumstances in accordance with the provision of this law. So that's what you're saying.
Yes.
The court gives a directive. So person should be granted bail and gives conditions for this bail. Now, looking at recognizance by parents or guardian of a child. Now, I'm talking about situation where the person involved is a child, and legally, the definition of a child is someone who is below 18 years.
Yes.
So, in a situation where a child who is below 18 commits an offense and is held by the police and has to appear in court, what is required in terms of bail?
Okay. In real life practical situations, what is required is for there to be a legal guardian, a legal representative of that child.
Okay.
For example, a child commits an offense and is brought before the court. More times than not, what we have in practice is that the child's legal representative or their blood relative is usually allowed to take them on bail.
And the reasons for this would be because the child isn't up to age?
Yes, that's why we say legal representative of the underage child.
So in this such situation, we're saying that if the obligation of this legal representative or guardian is to make sure that this child shows up.
Yes, in court, as at when due.
And in a situation where the child doesn't show up in court for one reason or the other,
The legal representative,
goes in for it.
yes.
Okay. Now, still on this 157, it says where a child is arrested with or without warrant and cannot be brought forthwith before a court, the police officer in immediate charge for the time being of the police station to which the child is brought shall inquire into the case and shall, except A, the charge is one of homicide, B, the offense charge is punishable with imprisonment for the term exceeding 3 years, and C, it's necessary in the interest of the child to remove him from the association with any reputed criminal. Now, this I'm going to come back to. I'm going to come to that later.
Okay.
Let's talk about A and B. What is it trying to explain? A and B.
It's pretty much, what we've talked about. We're talking about a child here. And even from the heading of that section, recognizance by parents or guardian of a child, it's not like it's more or less like taking responsibility for this child, taking charge from the definition of recognizance.
Okay, now in other words, is there some offense that a child would not commit that could make the judge deny him or her bail?
Yes, there are instances where bail can be denied
for a child.
We have instances of the person not being a first-time offender.
Okay.
Like if it's on record that you've done this again and over again. Instances like that, bail can be refused.
Now, also, the C part of it talks about releasing the child when when they intend to remove him or her from the association of any reputed criminal or prostitute. Means the court puts into consideration the association of this child while in jail. So, in other words, it's protection for the child.
Yes, it's protection for the child.
All right. Now, I would love to dig into that part more, but because of time, let's move on. Now, 2 reads, the parents or guardian of the child shall execute a bond for such an amount as will, in the opinion of the officer, secure the attendance of the child for the hearing of the child. So, what is that saying for those who might not understand this grammar?
Okay, that's talking about being a surety. But when you come to take someone on bail, you need to fill a form as the surety. You need to fulfill certain conditions with the court registry. When all of that is done, you can take the child.
Now, let's move to the bail where a suspect is charged with a capital offense. First of all, when we talk about capital offense, for those who cannot get their hands on exactly what a capital offense is, can we get examples of a capital offense?
Capital offense is an offense that is punishable with death.
Okay.
And for you to get bail on that on a capital offense, it can only be granted by a high court judge. And you can't just get that. It's not like it's automatic. You know, there are instances, the conditions that you have to prove before bail is granted in capital offense. For example, the defendant can prove that he has a health condition, and you know that has to be certified by a medical practitioner. There are also instances of an extraordinary delay in investigation exceeding 1 year. And then, I mean, like, there may be other circumstances that the judge may deem exceptional, and he will grant bail in such circumstance. That's section 1000 of the Act.
You would hear some persons believe that when some offense gets the capital punishment, that person should never be granted bail. Does this make sense?
No, take that again.
Like some people believe, what since the person is about to get the capital punishment, why should this person even get bail? You think it's risky?
Well, I think it depends on the mood of the court, and the mind of the court. Like I said, I mean, in as much as you're going to get you're going to get punishment by death, capital for a capital offense, you can still apply for bail.
Now, we're moving on because we're trying to cover up every section of this part now. It's in because of time. Bail when the defendant is charged with offense exceeding 3 years imprisonment. What happens in this case? But I'm talking about situation where the punishment, the sentencing might exceed 3 years. So how does bail come into play in this case?
Okay, so like for every offense, there are offenses that we basically call bailable offenses. Bail, first of all, I didn't mention this, is at the discretion of the court. So now, the court is supposed to be bail ordinarily, but there are instances where the court may not grant bail. Example, okay. You have reasonable ground to believe that this person, this defendant, is going to commit the same offense again, or just go and not be law abiding. Let me use that word. There will be instances where the person may attempt to evade arrest, or the person may attempt to evade trial. You know, sometimes when young people they don't attend trial, then you now have to get a bench warrant and all of that. Sometimes there may be, you will believe that there will be an attempt to influence investigation, interfere with the investigation, intimidate the complainant. I mean, those are instances where
the court may refuse bail.
Yes, the court may refuse bail. You may try to conceal or destroy evidence. You know, there are a lot that can lead the court to refuse bail. Example, now I said that earlier, but I think I would like to repeat that again, because there are instances where you believe that the person is going to commit an offense again as soon as he leaves that spot. Why? Because he's done that over and over again. It's on record. You'll even hear the prosecutor say it's on record that this person, he's not a first time offender, neither is he a second time offender. So like, when you have such instances, you don't have an option than to sometimes refuse bail.
Right, now still on the angle of this is exceeding 3 years. When it comes to bail, how easy is it to get bail when the punishment exceeds 3 years?
Well, generally, not just for punishment that exceeds 3 years, it's in our law. I think section. Well, I can't really get hold of the section right now, but bail is not supposed to be, the bail conditions are not supposed to be excessive.
We're going to come back to that when we come back from this break, because that's going to be an interesting part in terms of conditions to meet when getting bail. But don't forget that you're still on to Will of Justice, and it comes to you 3:30 every Tuesday. It's brought to you by the Acjl State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action, that is PROWA, with the support of the Open Society Initiative for West Africa, OSWAT, and the Acjl State Justice Reform Team. And we're talking about bail and recognizance, generally under sections 155 to 168 of the Acjl 2017. And I was speaking with His Worship Uzo Ona, who has been breaking down different sections of the bail. When we come back, we'll continue. We'll be looking at more areas of bail and recognizance, and also we're going to talk about the conditions to be met when it comes to bail. Just stay tuned. Still Will of Justice.
The need of justice. The good cannot cry out for justice. It is a duty of the living to do so for them.
Welcome back to Will of Justice, and I did say my guest today is His Worship Uzo Onwaha, who is the Magistrate Court aide, Umaya North, more like the headquarters. And we've been looking into bail and recognizance generally under sections 155 to 168 of the Acjl 2017. We've got very few minutes left in the program today. So, in order to catch up, we're going to move into conditions of bail. And sometimes we've heard about certain conditions that might seem out of place. Let me use the word out of place, or might seem excessive. So, based on the Acjl, are conditions for bail supposed to be that, that big, that hard to get?
Okay. Just before one of the break, I spoke about section 162, and like I said, conditions for bail are purely at the discretion of the court. Okay, right? And then again, it also depends on the offense for which the defendant has been brought to court. Right. So, generally, when we talk about bail conditions, a simple offenses, sometimes hear us in the language of the court. Sometimes we hear us say stuff like the bail is hereby granted to defendant in the sum of, say 100,000 naira in like sum, with the surety in like sum. Now, some of the conditions that we give the surety, like I mean, you can hear us say something like the surety will submit 2 passport photographs, 2 clear passport photographs, recent passport photographs. You hear us say the surety must reside within the jurisdiction of the court, or from the magisterial district where the matter emanated from. You also hear us say
Have
landed property. Yeah. You also hear us say person must not be a tax offender, meaning that the person is going to bring the tax clearance certificate. You could also hear us say that the surety will be recommended by the traditional ruler of where he is from, the magisterial district where that charge emanated from. You also hear us say so and so person bring us a public utility bill. That way we know that you actually reside where you say you do. and then like a court bailiff or the police officer attached to that court will be expected to go and do a visitation and make sure that you actually live there. And then recently, with the introduction of the national identity card, you have the NIN numbers there.
Yeah.
Yes, and you can also use that to identify who these sureties are, who is coming to take them on bail. Furthermore, sometimes we issue an extra caution to the defendant, asking them to be of good behavior.
Okay. Now, because of time, there's a part of this law that talks about the judge reviewing the bail condition put in place by the magistrate. It's this clear. Is the law clear on this?
Yes, the law is clear on that. A judge can revoke or review the bail conditions. This application is usually made by the Attorney General of the state.
Okay.
It comes from the office of the Attorney General.
Okay. Now, in a case, usually the Attorney General is usually the prosecutor sometimes. In a situation where the defendant, doesn't like the bail condition, can the defendant reapply for the bail to be reviewed?
Very clear on that.
Okay. Okay. All right. Now we are almost out of time. We're almost out of time. So we're gonna just go through the last part of it, and that's talking about we're talking about reconstitution of bail. We just talked about this right now. Before whom recognizance may be executed. Right. So the terms of recognizance fixed by the court in respect to any sureties shall be processed in that court. And recognizance, as mentioned in subsection 1 of this section, to be entered into by the parties before any other court. Any registrar, superior police officer, officer in charge of the police station, or any official in charge of the prison. Please, in just 1 minute, could you explain this?
Okay, so what this just means is that once recognizance is executed, it has the same effect as if it was executed in that court, in the court where it was granted. And it is not only granted in that court, it can be granted by the police officer, superior police officer in that police station where the defendant was brought from, or a senior officer of the prison. Now, the defendant is expected to be released upon the execution of recognizance. Like the court issues a written order of release, and once it is presented, when you issue an order, you sign off on it. Once it's presented at the prison, the police station, wherever it is, the defendant is immediately released.
I think we'll have to stop because of time. We're out of time. But it does continue, and through some subsequent editions, we get to look at the other parts of bail and recognizance. I want to say thank you very much for having the chance to come in and explain this. And hopefully, we can have a better understanding of how the bail system works in terms of recognizance. I was speaking with His Worship Ozo Onwa, who's Magistrate Court 8 in North, and we've been looking at bail and recognizance generally under sections 155 to 168 of the Acjl 2017. Well, we've come to the end of the 6th edition of Wheel of Justice. Please do not forget, this is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Power, with support of the Open Society Initiative for West Africa, OSUA, and Abia State Justice Reform Team. A big thank you very much to our guests who is representing Power here today. My name remains Steve. While coming up next is Fluoride with Venus. So make sure you stay tuned. Bye for now.